Call 109-240 in the matter of David Druten. Is the respondent present? Does not appear. No appearance.
May it please the court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. On November the 8th, 2012, a hearing panel convened on the formal complaint alleged against the respondent. The respondent, prior to the hearing, had been served with the formal complaint, notice of the hearing, and the list of exhibits and witnesses, both by certified and registered mail, as well as a supplement to the formal complaint by registered and certified mail, as well as personal service by an investigator from the office handing the documents to the respondent. Yet, the respondent did not appear. The hearing proceeded in his absence. On review before this court, the clerk of the Kansas Appellate Courts in March provided a docket letter to the respondent, both by certified and registered mail, as well as a letter of appearance in April, both by certified and registered mail. The formal complaint alleged, in essence, that the respondent was retained to represent his client in a personal injury, product liability, a cause of action, and just blotched it, just failed to meet court orders, failed to meet discovery, did not conduct really any legal work, and the case was dismissed. The hearing panel, based on the evidence they heard, found that the respondent committed 7 different rule violations. 3 of the 7 were multiple violations. At the panel hearing, I recommended that the appropriate discipline in the case was disbarment. My recommendation was based on the injury caused to the client. That was dismissal of his cause of action, as well as that in 1999 there was a very similar attorney disciplinary case against the respondent in which similar rule violations were found by the panel. The hearing panel agreed with the recommendation and recommends to this court disbarment. The respondent in this case did not file exceptions to the final hearing report. Accordingly, the disciplinary administrator asked that this court affirm the findings and the conclusions of law and adopt the recommendation of the hearing panel for disbarment.
Did he ever do anything in relation to the disciplinary matter?
Yes, he did, Your Honor. When the complaint was initially docketed, the respondent did provide a letter in response to that, both to the office as well as to the investigator. The investigator did have 2 communications with the respondent in which he promised to provide material and records, but
I guess I did, but that was it.
That was it.
Okay.
Any other questions? Thank you. We'll take this matter under advisement.
Thank you.
With that, court will be in recess.